says I'm supposed to be in a Zoom hearing at 1:30 with Kimberly Foster. I thought so. Okay. All right. Case number 25CV078, Jamestown Funding Trust versus James R. Larkin. This is a hearing on a motion that Mr. Larkin filed pro se to dismiss, and the court notified the parties and counsel of record, Ms. Woods, and you're Ms. Upgrove, right?
Yeah, we have to.
All right. Have you entered an appearance in the case?
No, Your Honor.
Well, under the rules of superintendence, the attorney that files the case is an attorney of record, and no attorney is supposed to appear in the case unless they've entered an appearance. So I'll give you the break this time. Also, your attire is not appropriate. If you look at local rule, the dress for female attorneys is business attire, not casual. I would call that business casual, not formal. So in the future, make sure you address appropriately. All right, Mr. Larkin has not appeared, and the matter was set for 1:30. It's now 1:39. And his motion is based upon a statute of limitations, and he cites the statute 230503, which is actually the statute that bars bringing an action that exceeds a limit set forth in other statutes. He says it's 8 years. And actually, the statute he's referring to is 230506, which as of June 16, 2021, was amended to be 6 years. And so he does have the correct, he doesn't have the correct one, but that's because the law's changed. But anyway, he's not here to advocate on behalf of that. Ms. Upgrove, I don't know how much information you have on this case, but do you know when the date of default was on the complaint or on the account?
Well, it was the last payment that he made, that the defendant made on the account was 8/7/2022. He was making payments regularly.
8/7/2022. Okay.
Yeah, 10/7/2022.
I'm sorry, 10/7/2022. Okay.
Was the last payment he made.
All right, because he said in his motion that the last payment he made had been more than that. Okay. Well, the court's going to, since he's not here to act on to present evidence, he's failed to appear. And if he were to argue that were not accurate, that is not accurate, that it would require a finding of fact, which therefore means that there would be a cause of action assigned or alleged, so therefore it would not be subject to a motion to dismiss anyway. Based on that, the court will deny the motion, and I'll issue a scheduling order.
Thank you.
All right, thank you. The other hearings are by Zoom, right? All right. It's case number 25 CR 32, State of Ohio versus Liam G. Souders. And are you Liam G. Souders appearing there by Zoom from the jail? All right. This is a hearing on a plea. Mr. Souders' attorney is Jacob White, appearing from his office. Appearing on behalf of the state is Prosecuting Attorney King. I have before me a proposed plea agreement. Before I start on that, Mr. Wagner, are you and your client both in agreement that this matter can be conducted by Zoom rather than an in-person hearing?
We are, sir.
And are you all right with that, Mr. Souders? I'm sorry?
Yes.
Okay. Now, since you're not seated in the courtroom next to your attorney, if at any time you would like to speak with him or ask him a question, just tell me. I can put the two of you into a breakout room. It'll be just you and him on the screen, so nobody else will be able to see you or hear you that's on there now. And the deputy will step out of the room for your conversation to be confidential. Okay? All right. Now, Mr. Souders, I have before me this plea form, which indicates you're going to plead guilty to count 5 and count 6. I'm going to hold the first page of the agreement up to the camera to make sure you recognize it. It has the case number and your case name and the plea of guilty to those 2 counts. You recognize that document?
Yes.
Amen. It's not showing up over here. No. Oh, okay. Now it is. All right. Now, on page 3, there is a sentence that reads, I enter this plea voluntarily. Below that appears to be a signature, Liam Souders. I'll hold that up to the screen and ask if that is your signature.
Yes, it is.
Do you remember when you signed this document, Mr. Souders?
I do.
When was it?
Today.
Oh, today? All right. And when you signed it, did you understand that it was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes.
And did you go over it with your attorney and have him answer any questions and explain things to you before you signed it?
I did.
Do you feel that you had enough time to fully consider the matter before making the decision?
I do.
Do you feel that you were pressured or rushed in any way to make this decision?
No.
And you signed this agreement voluntarily?
I did.
And are you going forward with this plea today voluntarily?
I am.
All right, now the agreement states on page 1 that you're going to plead guilty to count 5, which is a forfeiture specification, which would result in the loss of the property that's alleged to be involved in that count. And in count 6 is aggravated trafficking of methamphetamine under 2925.03A1 of the Ohio Revised Code, which is a third-degree felony. And it says that with regard to the third-degree felony in count 6, that you understand that could carry a potential sentence of between 9 and 36 months imprisonment, a fine of up to $10,000, a mandatory fine of $5,000, and there's a presumption that prison should be imposed, although it's not mandatory. Do you understand that?
Yes.
Now, I believe you are currently serving a sentence, is that correct?
I am.
All right. So any sentence that you would receive in this case if you plead guilty could be ordered to be served consecutively to the current sentence you're serving. Do you understand that?
Thanks.
Now, are you facing any felony charges in any other jurisdictions?
I'm not.
All right. And do you have any sentences from any other jurisdiction, just the one sentence, or you have more than one sentence?
It's the one.
All right. Now, under the law, let me back up. You're not on probation or post-release control for any felony, correct?
Correct.
All right. Now, under the law, if you plead guilty and are sentenced in this case to a term of imprisonment, upon completion of that prison term, it is possible the adult parole authority would exercise the option under the law to put you under post-release control supervision for up to 2 years, which means you'll be supervised by a parole officer on the terms that they set. If during that period of time the parole authority felt that you were non-compliant, they could return you to prison to make you serve an additional period of up to 9 months for any single violation, but there's a cap or limit of half of whatever the prison term was for one or more violations total. However, if you're convicted of a new felony, while under post-release control. Then, in addition to whatever sentence a judge in the new case could impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. You understand that?
Yes.
Now, as I said, under the law, it's not a mandatory prison term, although there's a presumption there should be a prison term. And so what that means is that legally the court could, instead of sentencing you to prison, put you under community control or probation, meaning you'd be supervised by a probation officer under terms set by the court for a period of up to 5 years. And if during that period of time the probation department felt that you were not complying, they could file a written notification of that with the court. There would be a hearing at which you'd be entitled to have an attorney. And if the outcome of that hearing was that you failed to comply, then at that time, the court could revoke your community control and then sentence you to between 9 and 36 months of incarceration, fine you $10,000. And if your revocation was due in whole or part to a new felony conviction and you received a prison term on that, the prison term in that case, in this case, could be ordered to be served consecutively to one another. You understand that?
Yes.
All right, now count 5 alleges that on or about August 15, 2024 in Highland County, Ohio, you had in your possession a 2014 Honda Civic, and it was subject to forfeiture due to its instrumentality in the commission or facilitation of the offense as defined in ORC section 2941.14.17. And that would, if admitted, doesn't carry a prison term or a fine, but it does result in the loss of that property to the state. You understand that?
I do.
Count 6 alleges that on or about August 15, 2024 in Highland County, Ohio, that you and Courtney M. Jenkins did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount that equals or exceeds the bulk amount but is less than 5 times the bulk amount, in violation of Section 25.03A1. So that's the charge of aggravated trafficking of methamphetamine, the third-degree felony with the penalties I just described. Now, Mr. Souter, do you understand what you're charged with in each of those 2 counts, what the state said you did, when, where, and how they alleged that you did them?
I do.
And have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
I have.
Are you satisfied with his advice and confidence in this matter?
I am.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Have any threats been made to make you plead guilty here today?
No.
Now, on page 2, there are several lines that are printed in bold and underlined, which I will read as follows. Defendant will enter a plea of guilty to count 5 and count 6. State will dismiss remaining counts. State and defense jointly recommend 18 months incarceration to be served consecutively to the term of incarceration defendant is currently serving in case number 20 CR 274. Defendant agrees to forfeiture in count 5. Defendant agrees to cooperate fully with the task force, cooperate fully in the prosecution of the co-defendant. Defendant agrees to repay by money to the task force as follows: $80 alone and $65 jointly and severally with Courtney M. Jenkins. Now, is that your understanding of the agreement?
Yes.
Does anyone promise you anything other than that to make you plead guilty here today?
No.
Now, under the law, Mr. Souders, the matter of sentence is not recommendation, and the plea agreement is not binding on the judge. And so if you plead guilty, the court's not obligated to follow that recommendation. The court could decide after receiving all the information presented that that's not the appropriate sentence and could impose any sentence between the 9 and 36 months and a fine of $10,000. You understand that?
Yeah.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
I don't.
Now, you have certain constitutional rights, you must understand. Before I can accept a plea from you, first of all, you have a right to have counsel, and Mr. Wagner was appointed to represent you. That appointment wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you would like him to provide. So if you decide that you do not want to do this, that you want to defend against this charge, he will continue to represent you and defend you, including a trial, if that's what you want. Do you understand that?
I do.
Now, under the Constitution, you have a right to a jury trial, which means that 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are summoned, evidence will be presented, the judge would instruct them on the law, and then that jury of 12 would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial, and in that case you would have what's called a court or bench trial, meaning instead of a jury, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
I do.
Under the Constitution, Mr. Souders, you have a right to confront the witnesses against you and cross-examine them through your attorney in open court. What that means, the witnesses against you have to come into the courtroom and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney can ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that may help your side of the case. Do you understand that?
I do.
Now, under the Constitution, you have a right to confront the witnesses. You have a right to compel witnesses to come to court to testify on your behalf, the same as the state. So you would have the authority of the court behind you. In other words, if you have a witness you want to appear, you can file a request for a subpoena, which is a court order that the court would issue that would then force those people to come to court to be available to testify on your behalf if you wanted them to, even though they didn't want to be here. And that is the same way witnesses for the state are forced to come in and testify against you. Do you understand that?
Good.
Now, under the Constitution, Mr. Souders, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide that you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the case. And in fact, no one's even allowed to comment about it except in one situation. If there is a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Good.
Now, under the Constitution, you're presumed innocent of both charges until proven guilty by the state of Ohio on every element of each offense. So what that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've been indicted and accused. In fact, under the law, at trial, you don't have to present any defense at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charge by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Good.
All right. Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and then exercised or invoked all the rights I just described. If you change your plea from not guilty to guilty on these two counts, that's the complete opposite of the not guilty plea. The guilty plea will admit the allegations in counts 5 and 6, admit that they're a crime, that you committed that crime. And that plea waives or gives up all the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea is. But with that exception, a plea of guilty would waive or give up your right to a jury or court trial. Would waive or give up your right to use or to confront witnesses in open court and cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. Mr. King, are you still there? We lost your video.
Yes, Your Honor, I had to relocate rooms. I apologize.
Oh, okay, no problem. All right. It would waive or give up your privilege against self-incrimination because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. It also waives or gives up any right to file an appeal that you think you could have had up until this point in the case. Now, if I were to sentence you to the maximum sentence provided by law or under other limited circumstances, you could file an appeal. Any appeal would have to be filed within 30 days of your sentencing entry being filed with the clerk. You understand that?
I do.
Okay. Also, a plea of guilty will subject you to being sentenced immediately by the court, which is probably what's going to happen since that's there's no request for a PSI and you're already serving a sentence. So you understand that?
Yeah.
All right. And are you a U.S. citizen, Mr. Saunders?
I am.
All right. And do you have any questions about the charge in counts 5 or 6 or the penalties if you plead guilty to those counts?
No.
You have any questions about the plea agreement?
I don't.
You understand it?
I do.
Again, you understand that the recommendation on sentencing is not binding on the judge.
I understand.
You have any questions about the constitutional rights I've explained?
No, sir.
Do you understand those?
I do.
Do you have any questions about the plea of guilty, what it means, what will be the consequences if you enter that plea to these 2 charges today?
No, sir.
All right, you understand?
I understand.
Okay. Do you need to speak with Mr. Wagner about anything before we go any further?
Please.
All right. I will assign you into what's called a breakout room. You're going to have to click on the button that says Join Breakout Room. When you're done, you click on a button that says Leave Breakout Room, and then you'll have to click to be rejoined. So I'm going to hit Mr. Wagner. On them. All right. Now, Mr. Wagner, are your client still going forward then with this today?
Yes, sir. And if I can add, Your Honor, and I apologize because Mr. King was not the prosecutor I spoke with, but I know they're all hand in hand in their office. I believe Ms. Collins or Mr. King would represent that the state is okay with the plea also indicating no future indictments, specifically to a stop by Officer Hamilton in Greenfield. I believe that was the indictment we're talking about. Are you aware of that, Mr. King?
That's correct, and that would be an accurate statement.
So we
will not be pursuing charges for that incident.
All right. Well, even though it's on record here, I think the safest thing to do is for me to write that on the plea agreement so it's in the file clear. Is that okay with everyone?
We consent, sir.
That's fine, Your Honor. I don't know the exact date the incident occurred. Is the only.
It's related to a stop involving Patrolman Hamilton and Greenfield.
In Hamilton, Greenfield, on methamphetamine, and I'm aware of the details Ms. Collins and I spoke about today, sir.
Do you remember the date of that, Mr. Souders? The date that allegedly occurred?
You remember when?
I think it was September 6th.
Okay. Does that sound right, Mr.?
It could be possible. I have no idea.
Well, I'll just put in here that state will not seek
You're right, like I say, as defense counsel, I do have faith in the state, the prosecutor's office.
Oh, I agree, but again, it's just easier that if something comes up here down the road and one of you's not available or I'm not available, somebody can check it and see. They don't have to come back in and listen to the record.
Yes, sir.
A traffic stop by Greenfield Police Officer Hamilton.
Yes, sir.
Okay. All right. So I've added that to the second page or the third page of the indictment, and the portion that has the black and underlined plea agreement terms. All right. Then, Mr. Souders, is it your decision to withdraw your not guilty plea to counts 5 and 6 and plead guilty to those pursuant to the terms of the plea agreement? We've gone on over, that's in the agreement plus what I just added. I didn't hear you.
What are you asking?
Is it your decision that you're going to plead guilty to counts 5 and 6 in accordance with the terms of the written plea agreement plus what I just added to it here on the record about the Greenfield stop?
Yes, sir.
All right. Then, as to the charge in count 5, which alleges that on or about August 15, 2024, in Highland County, Ohio, you had in your possession a 2014 Honda Civic, VIN number stated in the indictment, and the property is subject to forfeiture due to its instrumentality. The commission of facilitation of the offense is defined in section Ohio Revised Code section 2941.14.17, which is a forfeiture that would result in the loss of that property to the state. How do you plead?
Guilty.
As to count 6, which alleges that on or about August 15, 2024, in Highland County, Ohio, that you and Courtney M. Jenkins did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount that equals or exceeds a bulk amount, plus less than 5 times the bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code, charge of aggravated trafficking of methamphetamine, a third-degree felony, carrying a possible penalty between 9 and 36 months imprisonment, a fine of up to $10,000 maximum, a mandatory fine of $5,000. How do you plead?
Guilty.
All right. The court finds that on this day in open court, the defendant was advised of all his constitutional rights to make a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. Please accept the order filed. The defendant is found guilty of counts 5 and 6. Counts 1 through 4 and 7 are dismissed. The court will go ahead and proceed with sentencing since the defendant is already serving a prior prison term, and there is a joint recommendation on sentencing. So at this time, I'll hear from the state.
Thank you, Your Honor. The state would ask that the court follow the joint recommendation. There is a forfeiture of a vehicle in this case. That forfeiture would be to the task force. Would ask that the clerk be ordered to issue a title for that vehicle to the county commissioners. And finally, would just ask that restitution be ordered as outlined in the plea agreement. That's all, Your Honor. Thank you.
Mr. Wagner.
Your Honor, I simply would ask the court to follow the recommendation of the parties. Mr. Souders obviously is serving a prison sentence, which is not a good sign for me. But when meeting with him today, I don't know why I say this, Your Honor, except for the fact that I told him this. He's a smart, articulate guy. I'm not sure what led him down this path, but he could be productive. He's only 29 years old. He's more than polite every time I speak with him. He's never been difficult. But I say this truthfully, Your Honor. I think if he serves his time here, if the court does go along with it, this guy could be productive if he can turn over a new leaf. I'll leave it at that, Your Honor.
All right, Mr. Souders, is there anything that you would like to say?
No, Your Honor.
Okay. Well, hopefully you'll listen to what your attorney said and take that advice. It's good advice. And there are people with worse records that have made comebacks and become very successful in life. So hopefully you can be one of those people. It is ordered and judged that you be and are hereby sentenced on count 5 to require that the vehicle specified therein be forfeited to the Highland County Task Force, and that the clerk issue a new title of that vehicle to the Highland County Commissioners. It's also ordered to be sentenced to a term of 18 months on count 3, and according to this, you have just the 1 day of jail time credit since you were brought back, and that'll be applied to that. That sentence is ordered to be served consecutively to the sentence you're currently serving. In the case out of this court, 20 CR, I forgot the number, 54, maybe 274. And the court finds that the consecutive sentence is appropriate since there's a joint recommendation on the sentence. The court also finds, I believe this offense was occurred while he was on community control in the other case. Is that correct?
I'm sorry, sir?
Was this offense committed while he was on community control or not? Guess not. Okay. Well, the court will find, though, that the defendant's course of conduct in this was different from the course of conduct in the other case, and that one single sentence would not adequately reflect the seriousness of the offense, and that the sentences being imposed in each of the cases is not disproportionate to the harm caused in those cases. And the defendant's criminal history of the previous conviction shows that it's necessary to protect the public. Now, upon completion of this sentence, Mr. Souders, it is possible the adult parole authority will put you under post-release control for a period of up to 2 years, meaning be supervised by a parole officer on the terms they set. If during the period of time you're under supervision, they determine that you have failed to comply with those conditions, they can return you to prison and make you serve an additional period of up to 9 months for a single violation, which in this case is half of your prison term, so that would also be the maximum that they could impose. However, if you commit a new felony while under post-release control, then in addition to whatever sentence the judge in the new case could impose upon you, the judge could also sentence you for committing that new offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that would have to be served consecutively as sentence in the new case. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it upon completion of your prison term, not while you're in prison, but once you get out, you can be permitted to do community service in this county and be given credit for each hour you work and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. And since you're incarcerated in prison and did not have the funds to hire your own attorney, the court will waive the mandatory fine. It's also ordered that you pay restitution to the Highland County Task Force through the Highland County Victim Witness Office escrow, victim escrow account, $80 singly, you alone, and $65 jointly and severally with the co-defendant, Courtney Jenkins. All right, is there anything further from counsel?
No, Your Honor.
All right, thank you. All right, are you Stephen Jacobs appearing there from the jail? All right, this is case number 25 CR 77, State of Ohio versus Stephen Allen Jacobs. This is a plea hearing being conducted by Zoom. This attorney is Jacob Wagner, appearing from his office, and appearing from the prosecutor's office, Assistant Prosecutor King. This matter is set for a plea hearing. I have a proposed plea of guilty form before me. Mr. Wagner, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person hearing before the court?
We are, sir.
All right. Is that all right with you, Mr. Jacobs?
Sure.
All right. So if you have any questions you need to ask Mr. Wagner or something you'd like to talk with him about before we go or while we're going through this, you just tell me. I can put you and him into what's called a breakout room. It'll be just the two of you talking to each other. No one else will be able to see you or hear you. And the deputy will step out of the room while that conversation is taking place. It'll be totally confidential. Okay? All right. Now, Mr. Jacobs, you're charged in a 6-count indictment, various counts of trafficking and possession of drugs and aggravated trafficking and aggravated possession of methamphetamine. I have before me a plea of guilty form, which indicates you're going to plead guilty to count 5. Now, I'm going to hold this up to the camera, the first page, has your name, your case number, plea of guilty, and the count to which you're going to plead guilty. Do you recognize that document?
Yes, I do, sir.
All right. And on page 3, there is a line that reads, I enter this plea voluntarily, and right below that is a signature that appears to be Stephen A. Jacobs. And I'll hold that up to the camera, and is that your signature?
Yes, Your Honor.
When did you sign this document, Mr. Jacobs?
Yesterday.
And when you signed it, did you understand it was agreement to plead guilty, which means that there won't be a trial? The next step in your case will be a sentencing hearing?
Yes, Your Honor.
And before you signed it, did you go over it with your attorney and have him answer any questions and explain things to you?
Yes, Your Honor.
And do you feel that you were rushed or pressured in any way into doing this?
Oh, Your Honor.
And did you enter into this agreement voluntarily?
Yes, Your Honor.
Are you going forward with the plea today voluntarily?
Yes, Your Honor.
All right, now on page 1 it says you're going to plead guilty to count 5, aggravated trafficking of methamphetamine under section 2925.03A1 of the Higher Vice Code, a third-degree felony. States that you understand that the maximum prison term for that could be 9 to 36 months. There's a mandatory fine of $5,000. The maximum fine possible is $10,000. And although prison is presumed, is not mandatory. Prison sentence is a presumed sentence that should be enforced but not necessarily required. All right. Do you understand that?
Yes, Your Honor.
And are you facing any felony charges anywhere else, Mr. Jacob?
No, Your Honor.
Are you currently on probation, parole, community control, post-release control for a felony?
No, Your Honor.
Now, under the law, Mr. Jacobs, if you do plead guilty to this offense and are sentenced to prison, when you complete that term, the Adult Parole Authority may put you under post-release control for a period of up to 2 years as part of the sentence. If they do, you'll be supervised on the terms they set by a parole officer, and if during that period of time they feel that you've not complied or they find that you have not complied, they can return you to prison to make you serve an additional period of up to 9 months for one violation, but there's a cap or limit of half of whatever your prison term was for all violations. However, if you commit a new felony, then in addition to whatever sentence the judge in the new cases can impose upon you, the judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
Now, under the law, as I said, I'm not required to impose a prison term, although it's presumed. So I could, instead of sentence you to prison, give you community control or probation, meaning you'd be put under supervision of a probation officer instead of going to prison for a period of up to 5 years under terms set by the court. And if during that period of time the probation department felt that you were not compliant, they would file a written notice that with the court, give you a copy. There would be a hearing at which you would be entitled to have an attorney to represent you. And if the outcome of that hearing was you had failed to comply, then at that time the court could revoke your community control and sentence you to between 9 and 36 months of incarceration, fine you $10,000. And if the revocation was due in part or whole because you had committed a new felony while on community control and you were sentenced to a prison term in that case, the term in that case, in this case, could be ordered to be served consecutively to each other. Do you understand that?
Yes, Your Honor.
All right, now, the charge in count 5 alleges that on or about September 16, 2024 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance amount equal to or exceeding bulk amount but less than 5 times the bulk amount in violation of Section 2925.03A of the Higher Vice Code, which is the charge we're talking about with the penalties I just described. Mr. Jacobs, do you understand what it is the state is accusing you of having done, when, where, and how they allege that you did those things?
Yes, Your Honor.
Did discuss the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of that trial with your attorney.
Yes, I did.
And are you satisfied with his advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to get you to plead guilty here today?
No, Your Honor.
Now, on page 2, there are 3.5 lines printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 5. State will dismiss remaining counts. State and defense jointly recommend 18 months incarceration. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay bond money to the task force in the amount of $250. That's your understanding of the agreement.
Yes, Your Honor.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, Mr. Jacobs, the matter of sentence is not up to the parties, it's up to the judge. So if you plead guilty, even though there's a recommendation by both parties as to what the sentence ought to be, the judge is not required to follow that. I could impose any sentence that I think is appropriate under the law, which could be between 9 and 36 months incarceration and a fine of $10,000. You understand that?
Yes, Your Honor.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in this state? I'm sorry, I didn't hear you.
No, Your Honor.
All right. Now, you have certain constitutional rights, you must understand, before I can accept a plea of guilty from you. First, you have a right to have a jury trial in this matter in which 12 people would be selected from a group of citizens that live in Highland County that are selected to appear for jury duty on your trial date. After 12 of those individuals are selected, the evidence is presented. The judge instructs them on the law, and then that jury of 12 decides by unanimous verdict, meaning all 12 have to agree, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means you give up. The right to have a jury trial, in that case, you would have to call it a court or bench trial, meaning instead of a jury, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to confront the witnesses against you in open court to cross-examine them through your attorney. What that means is that the witnesses against you must come into court and testify in front of you and your attorney and anyone else who may be present, because it's a public proceeding. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, Your Honor.
In the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses, you're not certainly going to come in voluntarily. At your request, the court issues a court order, it's called a subpoena, and that forces those people to come to court and be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. Do you understand that?
Yes, Your Honor.
In the Constitution, you're presumed innocent. You have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you do not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right. They cannot consider that for any purpose. Do you understand that?
Yes, Your Honor.
Now, in the Constitution, you have a presumption of innocence, which means that you're presumed innocent of each of these of this offense until proven guilty by a proof beyond reasonable doubt by the state of Ohio. So the burden isn't on you to try to prove you're not guilty. In fact, at trial, you don't have to put on any evidence at all. You may, but you're not required to. Whether you do or not, the burden of proof remains on the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, originally, you entered a plea of not guilty. Not-guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I just described. If you change your plea from not guilty to guilty on this charge, that's the complete opposite of the not guilty plea. That plea would admit the allegation in count 5, admit that it's true that you committed the crime, and that plea would waive or give up all the rights I've described for you today except one, your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up the right to a jury or court trial, waive or give up the right to confront the witnesses against you and cross-examine them through your attorney, waive or give up the right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It would waive or give up the privilege against self-incrimination because if you say you're guilty, the state is not required to prove you're guilty. And that's what you can find you guilty. It waives or gives up the presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives or gives up the right to file an appeal on any alleged violations of your rights you think could have occurred up until this point in time. Now, if I should sentence you to the maximum sentence under certain limited circumstances, you could file an appeal. That appeal would have to be filed within 30 days of your sentencing after being filed. Do you understand all of that?
Yes, Your Honor.
Are you a U.S. citizen, Mr. Jacobs?
Yes, I am.
Now, do you have any questions about the charge in count 5 or the possible penalties?
No, Your Honor.
You understand them?
Yes, I do.
Have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, I do.
Have any questions about the plea of guilty, what it means, what the consequences of that would be if you entered here today?
No, Your Honor.
You understand?
Yes, I do.
Now, do you need to speak with your attorney before we go any further?
No, sir.
Is it your decision then to go forward with this plea of guilty pursuant to the terms of your plea agreement?
Yes, sir.
Can you do that voluntarily?
Yes, Your Honor.
Then as to the charge in count 5, which alleges that on or about September 16, 2024, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of Section 2925.03A1, the charge of aggravated trafficking in methamphetamine, a third-degree felony carrying a possible prison term between 9 and 36 months, a maximum fine of $10,000, a mandatory fine of $5,000. How do you plead?
Nothing.
All right, the court finds on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. Please accept the order filed. Defendant is found guilty of count 5. Counts 1 through 4, count 6 are dismissed pursuant to the plea agreement. The court will go ahead and proceed with sentencing due to the joint recommendation of the parties, and the court did review the previous criminal record in the state's compliance with discovery and feels that that's appropriate given his record. So, anything from the state?
Only was contained in the plea agreement, Your Honor.
Mr. Wagner?
Your Honor, we would ask the court again, like the state has indicated, to follow the recommendation. This is a case that I've been with Mr. Jacobs. At no step along the process was he combative or difficult to deal with. Rightfully so. You just simply want to go through all this discovery, look at the videos, which we've done. We just ask the court to follow the recommendation, sir.
All right, Mr. Jacobs, anything you'd like to say? Anything at all?
No.
All right. Then it's a judgment order of the court that you be and are hereby sentenced to a term of 18 months incarceration at the Correctional Reception Center in Ohio. You'll be given credit. According to this, you were arrested. It says you have 28 days of jail time credit, so that would have been sometime in May. Is that correct?
Yes, Your Honor.
All right. Now, upon completion of that sentence, it is possible the adult parole authority will put you under post-release control for a period of up to 2 years. If they do, you'll be supervised in the terms they set by a parole officer. And if during that time they find that you have failed to comply, they can return you to prison to make you serve an additional period of up to, in this case, 9 months for one or more violations. That's also the cap. However, if you commit a new felony, then in addition, whatever sentence the judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which the judge will grant and execute the order. If you fail to do that, then the clerk can collect that through various means, including levy on bank accounts, wages, or other earnings you may have. If that doesn't collect it upon completion of your prison term, but not while you're in prison, the court could permit you to do community service in this county and give you credit for each hour you work. And then on a rate set by the court, each hour you work will reduce your judgment by that amount until paid in full. It's also ordered that defendant pay restitution to the Highland County Task Force, amount of $250, which is payable through the Hyden County Victim Witness Restitution Escrow account. You'll pay any service fees associated with that. And Mr. Jacobs, has there been any change in financial circumstances since I appointed Mr. Wagner? All right, then the court will waive the mandatory fines and find that the defendant has no ability to pay it at present and is unlikely to in the future. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded back to custody. All right, I'm going to do All right, are you Donnie Jenkins, Jr.?
Yes, sir, Your Honor.
All right, this is case number 25-CR-74, State of Ohio versus Donnie Jenkins, Jr. Mr. Jenkins, you were arrested by or indicted, I should say, by the grand jury on May the 6th on a charge of tampering with evidence in count 1 and aggravated possession of methamphetamine in count 2. It alleges in count 1 that offense occurred on or about January 16 of 2025 and that you did, while an official proceeding or investigation was either in progress or was about to be likely to be instituted, alter, destroy, conceal, remove any record, document, or thing with purpose to impair its value or availability as evidence in the proceeding or investigation. So that's a violation of Section 2921.12A1 of the Ohio Revised Code, a third-degree felony, which, if convicted, carries a possible sentence between 9 and 36 months and a fine of $10,000. Now, count 2 alleges on or about the same date and time and place that you did knowingly obtain, possess, or use a Schedule II controlled substance methamphetamine, and violation of Section 2925.11 of the Ohio Revised Code, and that is a fifth-degree felony which carries a possible prison term of between 6 and 12 months, a fine of $2,500. Now, you're entitled to have an attorney to represent you, and if you don't have the money to hire one, the court will appoint one for you, and I see you have filled out a financial disclosure form. Is everything on that? Well, let me see. I thought I saw it in here. Did you see one here, Ben? Because I don't see it in here. Okay, well, I can't find it, so if you would fax that back up to me, Deputy Malone. Is everything on your financial statement correct, Mr. Jenkins?
Yes, sir.
All right. And you're not employed currently?
No.
All right. All right. The court then will find that you're entitled to appointed counsel. I'll appoint Attorney Dennis Kirk of Hillsborough, Ohio, to represent you in the absence of counsel on a not guilty plea. We'll set a bail review hearing for June the 5th at 8:30 a.m. by Zoom. Your first pretrial will be June 25 at 1 o'clock. Your final pretrial will be July the 16th at 1 o'clock, and your trial date will be August the 11th at 8 a.m. Bond will be set in the amount of $10,000 plus your own recognizance, which is your promise to appear. If you fail to appear, then you could be prosecuted for an additional felony and convicted, sentenced on that, no matter what happens in this case. You'd be under pretrial supervision of the probation department, 117 East Main Street, meaning you have to be that you'll report to them immediately upon your release, once a week for 4 weeks, and after that, as they determine. undergo random drug testing in May order, provide phone numbers for home cell employer, recommended by probation be evaluated for substance abuse or mental health issues, make treatments indicated, enroll in and follow that during the period of this action. And what is your residence address, Mr. Jenkins?
201 North 2nd Street, and that would be in Greenfield, Ohio, sir.
All right. So you'll be under house arrest at that residence unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of job training, educational programming of any sort, and then also you may attend church services. Other than that, you have to be there at all times. We will notify your attorney of his appointment, and we'll have your review hearing Wednesday morning at 8:30. All right, thank you. Unmute yourself there on the screen. All right, thank you. Case number 25 CR 73, State of Ohio versus Joseph N. Oliver. You're Joseph N. Oliver, appearing there on the screen marked HCPD.
Yes, Your Honor.
All right. Mr. Oliver's attorney is Jacob Wagner. This is a hearing being conducted by Zoom. Mr. Wagner is appearing from his office. Appearing on behalf of the state from the prosecutor's office is Assistant Prosecutor King. This is a matter set for a plea hearing. And Mr. Wagner, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
We are, sir.
And you're all right with that, Mr. Oliver?
Yes, sir.
All right, since you're not in the courtroom seated next to him, at any time, if you have any questions for him or would like to talk to him about anything, you just tell me, and I'll put the two of you in the breakout room. It'll be just the two of you on the screen. No one else will be able to see you or hear you. All right?
Okay.
All right, now, Mr. Oliver, you're charged with failure to comply with the order of signal police officer, third-degree felony, and I have here before me a plea of guilty form, which says you're going to plead guilty to that charge. I'm going to hold up page 1 of the document as your name, case number, plea of guilty, and count 1. You recognize that document?
Yes, sir.
And on page 3, there is a line that reads, I enter this plea voluntarily. And right below that, there's a signature line with what appears to be Joseph Oliver to me. I'll hold that up to the camera, and is that your signature?
Yes, sir.
When did you sign this agreement, Mr. Oliver?
It was, I can't remember the exact court date. It was, last week, Your Honor. Last week.
All right. Well, okay. So, when you signed it, did you understand it was agreement to plead guilty, which means there's not going to be a trial, and the next step in your case will be a sentencing hearing?
Yes, Your Honor.
And before you signed it, did you go over it with your attorney and have him explain everything and answer any questions?
Yes, Your Honor.
Do you feel that you were rushed or pressured in any way into doing this?
No, sir.
Since there's been a few days, a week or so that has passed, have you had any change of heart, or you still want to go for it?
I'll still go for it, Your Honor. All
right. Now, the agreement says you're going to plead guilty to the charge, which is failure to comply with the order signal of a police officer under Section 2921.331B of the Ohio Revised Code, third-degree felony. It further states that you understand that the maximum penalty for that could be between 9 to 36 months in prison. There is a possible fine of up to $10,000. There's a mandatory license suspension of at least 3 years, could be up to life. And if you are sentenced to prison on any other offense at any time, this sentence has to be served consecutively to that. Do you understand that?
Yes, sir.
All right. Now, are you facing any felony charges anywhere else?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
Not other than, no, sir. Just in pretrial supervision, Your Honor.
All right. Now, under the law, Mr. Oliver, if you should serve a prison term in this event, in this case, if you plead guilty, upon completion of that prison term, it's mandatory you be put under post-release control, supervision for a period of at least 18 months, 1 year, up to a maximum of 3 years. And you'll be supervised under a term set by the Adult Parole Authority. They'll decide how long the supervision is to be as well. If during the period of time you're being supervised, they determine you've not complied, they can return you to prison to make you serve as a sanction an additional period of up to 9 months for any one violation. But there is a cap or limit of half of whatever the prison term was for any and all violations. However, If you commit a new felony while under post-release control and are sentenced to prison for that offense, then that judge is also authorized under the law to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively the sentence of the new case. Do you understand that? Do you understand that?
Yes, Your Honor.
All right. Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control, or probation is what most people know it to be. And that means that instead of being sent to prison, you'd be put under supervision of a probation officer for a period of up to 5 years under terms set by the court. If during that period of time the probation department felt that you were not complying, they could file a written notice with the court. There would be a hearing, and if the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for between 9 and 36 months, fine you $10,000. And if you had been convicted of another felony offense during that period of time and were sentenced to prison for that, the sentences in the two cases could be ordered to be served consecutively to the other. You understand that?
Yes, Your Honor.
All right, now this indictment alleges that on or about March 3, 2025 in Hainan County, Ohio, you did operate a motor vehicle as defined in ORC section 4501.01 so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle caused a substantial risk of serious physical harm to persons or property in violation of section 2921.331B of the Ohio Revised Code. The charge of failure to comply with or signal a police officer, a third-degree felony, the possible penalty between 9 and 36 months incarceration, a fine of $10,000, and a mandatory license suspension of at least 3 years up to life. How do you plead? I'm sorry. That's the charge. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
And have you discussed the nature of those charges, the evidence in the case, possible legal issues in the case, possible offenses you might try to raise at trial, and the possible outcomes of your trial with an attorney? With your attorney?
Yes, Your Honor.
You're satisfied with his advice and confidence?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Now, on page 2, there are a couple lines printed in bold which read as follows, and are also underlined. Defendant shall enter a plea of guilty to the indictment. State defense jointly recommend community-controlled substance abuse treatment. That's your understanding of the agreement?
Yes, Your Honor.
Anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Under the law, the matter of sentence is up to the judge, not the party. So even though there's an agreement as to what the sentence ought to be, the court is not bound by that. So if you plead guilty, once I've heard all the information presented, if I decide that's not the appropriate sentence, you could get any sentence between between 9 months and 36 months. You could get a fine of up to $10,000 and a mandatory fine of $5,000. And also, I'm required to sentence you to a 3 years of license suspension by law. You understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
Now, you have certain constitutional rights, you must understand, before I can accept your plea. First of all, you're represented by Mr. Wagner, because you do have a right to have an attorney in these matters. And he was appointed since you didn't have the money to hire an attorney. His appointment was not simply to get the case worked out, but to provide any defense that may be available to you under the law that you'd like him to provide. So if you decide you do not want to do this, that you would rather defend against the charge, he'll continue to represent you and defend you, including a trial, if that is what you want. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to have a jury trial in this matter, Mr. Oliver, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial day. After they are selected, the evidence will be presented. The judge would then instruct them on the law, and then that jury of 12 would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you could have what's called a court or bench trial, meaning that instead of a jury, it would be the judge would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court in public and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that may help your side of the case. You understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order, it's called a subpoena, and that would force those witnesses to come into court to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. You understand that?
Yes, Your Honor.
Now, in the Constitution, you have privilege against self-incrimination, which means that you cannot be forced to give evidence or to testify in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one's even allowed to mention or talk about that except in one circumstance. If there is a jury trial and you do not testify, the judge does instruct the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all in your defense at all at any time, including trial. You can, but you're not required to. But whether you do or not, the burden of proof will remain on the state of Ohio to prove your guilt on every essential element of this offense by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
Now, under the Constitution, you're presumed innocent. I already explained it to you. All right. Now, under the Constitution, when you entered your plea of not guilty, you exercised all the rights I just described. If you change your plea to guilty, then that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. That plea waives, gives up all of the rights I've described for you, except your right to have counsel. You always have a right to have counsel no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial, waives, gives up your right to confront witnesses against you and cross-examine them in open court, waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. Waives, gives up the privilege against self-incrimination because you're saying you're guilty, that's what's used to find you're guilty. Waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. Subjection means sentence made by the court. And finally, waives, gives up any right to file an appeal you think you could have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes, Your Honor.
Again, you understand the recommendation on sentence is not binding on the judge.
Yes, Your Honor.
Now, you have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
Is there anything you need to ask Mr. Wagner about before we go any further?
No, Your Honor.
Then is it your decision to go forward with this plea agreement today and enter a plea of guilty voluntarily?
I'll wait a moment for them.
All right. All right, now,
Back, Your Honor.
no problem. All right, Mr. Wagner, you and the client both ready to continue?
All squared away, sir.
All right, so Mr. Olvers, it's your decision then to withdraw your not guilty plea and plead guilty to the charge according to the terms of the plea agreement we just went
Yes,
over.
sir.
And as to the charge, which alleges that on or about March 3, 2025 in Highland County, Ohio, you did operate a motor vehicle as defined in ORC section 4501.01 so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop. And the operation of the motor vehicle causes a substantial risk of serious physical harm to persons or property in violation of section 2921.331B of the Ohio Revised Code. The charge of failure to comply with the order to signal a police officer, a third-degree felony, carrying a possible prison term between 9 and 36 months, fine of up to $10,000, a maximum fine of, or a mandatory fine of $5,000, and a mandatory sentence of suspension of license of 3 years to life. How do you plead?
Guilty, Your Honor.
All right. The court finds in this day in open court, defendant advised of all his constitutional rights made no intelligent voluntary waiver of the same pursuant to criminal 11. The pleas accepted order filed. Defendant is found guilty of the charge. The matter is referred to the probation department under the same bond for a pre-sentence report, which shall include an assessment for substance use disorder and or mental health issues. Sentencing will be held on July the 2nd at 9 a.m. Bond to be continued. So you see Officer Benson to arrange your pre-sentence interview. All right. Is there anything further from counsel?
No, Your Honor.
No, sir.
Mr. Wagner, if you would stick around, then I want to ask you a question about